Dr. Gishankar sir to today's session. Welcome, sir, and thank you for taking time for us. Thank you.
Thank you, Bismi first and Grishma. It's a wonderful opportunity for me for associating with the initiative of the Department of Lifelong Learning of MG University. Uh, Briefly responding to what Bismi has said, every teacher is a construct of student, and so the responsibility to keep the teachers on their feet is up to the students, and that's what I have learned all these years. So anyway, uh, uh, it's my pleasure to uh, be with you all in this evening to share some stray thoughts on the topic progressive constitutionalization of rights as a catalyst, as far as in the broad backdrop of the theme of the online certification courses concerned, that is law and social transformation, contemporary issues. Every dialogue in law starts with constitution, because we keep constitution close to our chest, close to our hearts, in fact, which need to lit our ways, not only as a law student, not only as a law teacher, but as a human being in this country, or every country where we're having constitution. Even if written constitution is not there, but still the reflections of constitutional practices are there, without which a polity cannot exist. So when we talk about this very topic, see, the entire concept of law and social transformation, I think it is a multi-layered topic, capable enough to take us to not only hours, but also days of discourses or years of discourses, because that's happening every day. That is something being demonstrated before us every day. So particularly when we talk about the impact of constitutionalization of a range of areas, which have distinctly contributed to the social change and, more importantly, the social transformation in every nook and corner of our life. Constitution, or rather, how the handling of the constitution was made, how constitution was handled by various branches of government, legislature, executive, and judiciary, becomes so seminal. And only by understanding the dynamics and interrelationships and the concerted attempt to take the country forward alone, an understanding has to be generated on that. And this is an everyday learning also. This is not that we have listened to a lecture and then we have closed our minds to that. It's not like that. Because every day, every happening before us, in fact, takes us to these areas, provided we closely follow it. See, whenever we speak about the impact of constitutionalization in fueling social changes and social transformation, even though the terms social change and social transformations are interchangeably used, I think social transformation is much more demonstrable, and social change is a milestone in that particular journey towards transformation, because transformation should be visible before us. Transformation should have certain indices. It has to meet certain indices. It's a demonstrable outcome that the society reflects, which could be measured, or it's a measurable outcome. That's what I feel. Anyway, when we talk about the constitutional forays into the idea of social transformation, ever since our constitution has taken its birth, or even prior to its taking birth, the idea of constitution. I have heard uh, Mohan Gopal sir's lecture. I think that will remain in your mind as to the foundational aspects of constitution, or rather the idea behind constitution, or constitution as an idea, and its impact upon the polity all these years, and also the foundational aspects. He is beautifully lectured in the first session, where I heard him saying that constitution is, it's being constituted as a republic, so it should be understood in the present continuous form. That's the correct way of interpreting it, because it's continuing, it's evolving, it's emerging, and for that, that has to be punctuated by certain contributions, certain maybe corrections at some point of time, repair work at some point of time, etc. But then, when we talk about the transformative capabilities of this basic document, actually the vision behind making of that constitution, as well as continuously continuously being touched with that document and its dynamics across this part of the across the country, that becomes important. So even Ambedkar's vision that it would be a full-blooded democracy from the moment of its birth, India should be a full-blooded democracy, that in fact was resonating the transformative component. And his words, in fact, are very, very illuminating, where he forcefully, emphatically observed that we must make our political democracy a social democracy as well. And political democracy cannot last unless there lies at the base of it a social democracy. So then what does the social democracy mean? It means a way of life which recognizes liberty, equality, fraternity as the principles of life. So if you just can't leave Ambedkar at that particular point of time, but then for the sake of making, or rather cruising along this topic, fully acknowledging the vision of Dr. B.R. Ambedkar, we'll try to move a little bit forward. See, for a constitutional democracy like ours, the written constitution, I think, is the lodestar which has to lead our ways towards the future, our road towards the future. When I was learning my PG program, I don't know exactly which journal I have come across, but again, a forceful statement that I came across was from a US law journal, wherein the author was forcefully recording, or rather making his idea clear, that a constitution do have got fundamentals, and the fundamentals have to be very strong, and every day it cruises, every day it marches forward, meets with new happenings. That fundamentals have to keep it at its feet. But then a constitution is not steeped in fundamentalism. So for all these words are very, very important. So what exactly is constitutionalization? I feel that it's an endeavor to address and comprehend non-constitutional matters within the fold of constitution to address the felt need of the times. Something that is away from constitution, but then the ordainment of constitution should be there when we go forward, because constitution itself is an evolving document. The substratum will be there, but again, you have to continuously evolve, because that is for the society. So naturally, it is a political document, it is a legal document, and much more than that, it is an aspirational document. So naturally, it has to comprehend so many things which might not have found a place while that was being made, but that is part and parcel of the everyday life of that a human being in that particular country. So when you take into it's your fault when the persons who are responsible enough to interpret the provisions of the constitution, or somebody who is being installed in the constitutional capacities, try to comprehend some areas which are outside constitution essentially, but then giving a constitutional ordainment and making it part of the constitutional discourse, then see, so many caveats have been given by so many persons. Because will it be, or rather, will there be some, whether you need to take care of certain things that is very important, so that you will not strike a chord that is totally alien to the constitution. I was reminded of one particular case that was in Bowers was Hardwick. It is way back in 1986. I won't go to the facts, but only the principle, or rather the anxiety that was extended by Justice White when he was comprehending, when he was discussing about the employing judicial review on non-textual matters. That is, the Constitution didn't cover that particular area, but then that is being included within the constitutional discourse. So the case called for some judgment about the limits of the role of the court in carrying out its constitutional mandate. So according to him, his statement runs as follows: the court is most vulnerable and comes nearest to illegitimacy when it deals with judge-made constitutional law, having little or no cognizable roots in the language or design of the Constitution. When the language does not yield such an interpretation, when the design of the Constitution, original design as the Constitution, does not yield such an interpretation, how far it will be safe to draw in certain matters which is otherwise alien to Constitution within the scheme of things. So you should be very, very careful in that. Because again, this becomes part of the constitutional discourse, then naturally everything falls under the Constitution. And so this will be applied to the everyday lives of the citizens. Along with that, when we take into fold certain matters outside Constitution and then pass on moral judgments, even by employing judicial review, saying that, see, this particular right, which is part of this right, enumerated right, but the right that is being, the segment of right, or rather the exposition of that particular enumerated right, that is not being met by the legislature. So this particular law falls and is to be declared as unconstitutional, isn't it? So when you bring non-textual constitutional rights, that means rights that has not been part of the text of the constitutional rights, and then use it as a scale to assess a legislation, the capability of a legislation, the comprehensiveness of a legislation, then obviously you should be very, very careful in it, or otherwise we will get that could actually be a straying from that particular legitimate zones in which an interpreter of the Constitution is supposed to travel, isn't it? But so all these originalist thinking is there, textual thinking is there, and so many other thinkings are there, because that illuminates the constitutional discourses. But then that is being countered by the notion that, see, we being interpreter of the Constitution, we cannot remain within a shell. We have to see things outside. We have to see through things. We have to get a forensic eye, or our sight should be forensic enough. And then you have to see things around. And considerable time has lapsed since the document has come into existence. The complexion and flavor of the society has changed. The thinking process has changed. So you cannot remain static. And that is a level of autonomy that is being given to us. So usually that is being countered by the term, see, we have got that power. Let there be constitution, but constitution is what we say, isn't it? So that is one of the justifying ground for an extended application of constitutional principles over matters which otherwise does not fall within the constitutional, the design of the constitution. Another critical view is that uh, rights are of rights that are discussed in the constitution is having a magnitude. You call that magnitude as something that has been prescribed by the constitution. And if that is to be within the constitution, then that has to be found somewhere in the four corners of the document. And can you just import from outside, everything from outside, and then ordain it? That's this form part of this is concomitant of this particular right, or likewise. So these complexions of anxieties have always been there, but weighting of that anxieties, almost all the written constitution, the interpreters of constitution, whether it's India, whether it's US or some other countries, they have been part of the conserving aspect of constitution. It's not preserving constitution, it's conserving constitution. Conservation is totally different from preservation, where you have to enrich, add value to it. Because ultimately, a transformative component which emanates from constitution will have an enduring existence and which will have a very solid base, because laws have to be generated and then policies will be there before laws are being made. Before policies, certain philosophies are to be are to be given shape to, and then demonstrable outcomes have to be there when the law will come into force to the betterment of the society. So the society has to profitably engage in dialogue with the legislature, executive, etc., so that laws which are ordained, which are constitutionally ordained, which is poised for enhancing the well-being of the individuals, are there at the correct place. When we come back to our instance, there's the enlarging of the scope of Part 3 rights. Everybody is aware of it. The fundamental rights in Part 3 of the Constitution. When see the scope of fundamental rights that was there when the Constitution came into existence, how it was interpreted in various instances, the scope as well as the applicability of rights, then the various discourses that happened while interpreting rights in 1950s or 60s or 70s, the anchorage that was made, the spillovers, etc. See, the restrictions, the interrelation between entitlements and restrictions to fundamental rights. See, all these things have changed. So that means Part 3, the entire corpus of Part 3, while you employ a constitutional lens to measure the enhancement part of that, then the courts have, or the judiciary have successfully enhanced the scope of Part 3 rights, which is if you go across Article 21, isn't it? The list of unenumerated rights that encompass Article 21, which says that state shall not deny, or rather the personal liberty and life are the two enumerated rights. Then so many concomitant rights have been added within the corpus of personal liberty and also life, because life is a multi-layered concept. So many things constitute right to life. So it's a composite right. If it is a composite right, then every segment of well-being that could be added to meaningful existence. Francis Corelli, depending or rather relying on Mann versus Illinois, had very clearly stated that it's not the animal existence, it is a meaningful existence. So if it is a meaningful existence, then naturally, whatever makes, whatever resources, whatever conditions, backdrops that a human being requires to make his life meaningful, See, that encompasses the whole idea of right to life encompasses, and the state is vetoed. It's a negative right. That state shall not interfere with the scope of uh, life when it is guaranteed as a fundamental right. And also personal liberty, isn't it? Personal liberty. See the idea of dignity. How, in what way that has opened up the vistas. Dignity in so many ways, isn't it? So individual autonomy. So why Article 21 swelled like that? Because see, that has to be interpreted according to the changing times. So unenumerated rights form part of Article 21 in a big way. But then jurisprudentially speaking, what exactly is the difference between enumerated rights and unenumerated rights? All these things we have got large volumes of literature. Then Article 19.1, the freedoms, liberties that come under Article 19.1 A to G. In what way it has been shaped up? In what way it has been interpreted? Fundamental right to freedom of speech and expression. Then what all things that have been brought within the scheme of things of 19.1A. But we have got a sedate content under Article 19.2. You might be learning about Kaushal Kishore's case, the latest case, wherein the conflict between the fundamental freedom, particularly 19.1A and Article 21, is a hot discussion, because Part 3 or fundamental rights are those rights which you can claim against state. It's the vertical one. And whether it can be applied horizontally between people or non-state actors or private actors. But there the court, in fact, gave a ruling, or rather it expounded that 19.1A and 21 can be applied against the individual actors. See, all these, whether you like it or not, whether you criticize it or not, these are all expositions of rights which was granted some 70 years back or 70 or odd years back by virtue of the constitution that we have made for ourselves, to which we have submitted. But then the passage of time has really enriched not only the corpus, the spirit of the constitution, but when we interpret constitution, what should be given priority? Letter or spirit? Broadly, it is understood that the spirit of the constitution has to be taken care of. So letters have to be subjected to a forensic reading. So what I was telling you was that the Part 3 rights, example, Part 3 rights, if we take into account, then right to 21, right to travel abroad, right to privacy, right to shelter, right to health, free legal aid, right against solitary confinement, speedy trial, handcuffing, isn't it? Right against inhuman treatment, bonded labor, right against custodial harassment, right to reputation. So many rights that touches upon substantive aspects, and so many rights that touches upon procedural aspects enriches Article 21, isn't it? And these types of rights, which have been largely unenumerated, but which forms part of the basic rights that are guaranteed. Those unenumerated rights are largely called as implied rights, natural rights, background rights, which had made significant contribution in enhancing the level of existence of the persons or the individuals, isn't it? See, our basic growth lies in the fact that from subjects we have become individuals, isn't it? So just like it's a contractual constitution. We the people, isn't it? So where you find it's an emancipation from subjects to individuals that happen. So these types of conserving rights becomes a daily affair, which is a catalyst, which becomes a catalyst as far as the social change is concerned. When the society moves forward, naturally, this becomes very, very important, that the basic document also grows with that, or registers that mobility or momentum, and it shall not remain a stale document. It has to travel along with the times. So civil and political rights, which is the first generation human rights, which is part of the part 3, isn't it? So expounding the existing constitutional idea regarding the rights and then adding more things. That was what I was telling. That is also a process of constitutionalization, to dissect rights and find, or to expand the horizons of the right, so as to provide a wide coverage of rights to the teeming millions of this country. And then the part 3 rights, which are largely negative rights, the inter se relationship between negative rights, the part 3 rights, isn't it? Golden triangle. The Constitution does not speak about golden triangle, but when it is applied in the context, the text has to be read in the context. There we found that between 14, 19, and 21, there is an inextricable line of, or rather a relationship. Just like a cobweb, when one strand is disturbed, the disturbance, in fact, transcends to every single corner, isn't it? So all these are constitutional expounding, or expoundings based upon constitutional principles. Then not only part 3, but again the interrelationship between the part 3 rights and part 4 directives in part 4, isn't it? So when we talk about part 4, particularly the socio-economic rights, when we look upon in the angle of human rights, one of the most striking features of contemporary human rights is the juridical marginalization of socio-economic rights. When we embrace part 3 rights on very strong terms, the marginalization of socio-economic rights is always written on the wall. Not only in this jurisdiction, but in so many other jurisdictions, because it is being relegated as a status, relegated as a rights without resources. It is a right, but deferred. Progressive realization is the hallmark of that. So when we, again, how can we say that the Constitution has grown, Constitution has registered a momentum, mobility, when it encompasses new areas? So constitutionalization of socio-economic rights, isn't it? It reflects the need to protect the most fundamental interests of individuals in having resources that are necessary for the exercise of their well-being. So socio-economic rights depend upon intervention of the state. The language employed in our Constitution is very clear, isn't it? Intervention of the state in terms of resources, that is rights without resources. But lastly, we are excluded from the discourse of human rights. So for a better comprehension of socio-economic rights as a guarantee for ensuring the fuel for social change or even social transformation, you need to put it in put that fabric of thought or strand of thought within the constitutional idea. So that is where you find in almost countries having written constitution. For South Africa, for example, the things are much more progressive. But for those constitutions which in fact on the same footing as that of our country, the idea of progressive realization is always there. So when social rights are constitutionalized, they are to be transferred from, what is the necessary change that occurred to them? They are to be transferred from ordinary legal obligations or even positive or rather policy goals to that of obligations, constitutionally ordained obligations. That is very clear in the text of Article 37. Justiciability has been very clearly spelled out that it's not justiciable, but equally reinforced by one particular expression, fundamental in the governance of the country, isn't it? So directives are fundamental in the governance of the country. And similar words carrying, expressions carrying similar meanings are strewn around the entire corpus of Part 4, such as endeavor, primary duties, strive, in particular, direct, secure, state shall take steps, also obligations. So this duty complexion, having that duty, it's fundamental in the governance of country, that has to be borne by the legislative and executive wings. That is always there. And even in the matter of when you just analyze the interesting interrelationship between fundamental rights and the directive principles, how the constitutional courts have looked upon this particular relationship, the dynamics. The first step it said that it is non-justiciable, so relegated. Second side, it said that there should be fundamental, or rather taking cue from fundamental governance. It said that it's a sacrosanct aspect. Thirdly, third approach was that, or third phase says that there should be harmonious interpretation, both being the scheme part of one and the same scheme of things. And the fourth phase, constitutionalization, in fact, was so forceful that the ambit of the socio-economic rights got included within the scheme of things of Part 3 itself, isn't it? So this change has to be taken care of, because there again you find progressive constitutionalization and a compensatory approach towards non-justiciability has been embraced by the constitutional courts, isn't it? See, all this is for what? For the enhancing the well-being of the people in general. You might have heard of Amartya Sen, you might have heard of Martha Nussbaum, who had made significant contributions based on the work of esteemed Amartya Sen. And they have argued that human capability should form part of the definition of economic development, isn't it? Capabilities theory, you might be knowing that. And that social rights are key to protecting human capabilities. So it finds expression in so many other areas. That is why the Constitution has to keep its hands wide, or rather a flexible sort of approach has to be made, whatever that is possible, without tearing this fabric, that the essential fabric, how it can encompass, how it can improvise in the changing situation, that has to be looked upon. But even the interesting aspect is that, and you might be coming into terms with me if I say that progressive constitutionalization of Part 4 has happened, and the socio-economic rights have found its place as legitimate entitlements in so many levels of existence as far as the average Indian citizen is concerned, because of the progressive approach made by the constitutional courts. But then what's the impact of it? If we, apart from a simple declaration of, or rather a pronouncement, judicial pronouncement that this form part of this one, and hence the state is bound. But whether that declaration made by the judiciary has been reflected upon the other two wings, legislature and executive, interesting studies have come. It says that there has been wide support for including social rights in constitution. But whether on a systematic basis, whether these rights actually change how the governments provide social service to their citizens, I think the outcome is it's really scant. It's sorry. So adoption of social rights is not associated with the statistically significant or substantively meaningful increases in government spending. See, social security you have to extend, or so many other ameliorative measures you have to extend, housing, shelter, healthcare, so many things, insurance, and so many other areas. But whether the government has allocated, has included, had reflected on its spending domain posterior to the declaration of the right by the judiciary, generally we find that the substantive meaningful increases in spending on certain areas, education or healthcare, I think studies reveal that across the globe, this is very, very scant. So whether the constitutionalization of socio-economic rights have brought within demonstrable outcomes in the matter of enhancing the welfare and well-being, you find that the cue has not been taken from the judiciary. So another, that is part of the, we will leave that constitutionalization aspect of part 4 there. Then constitutionalization can happen in other areas like alternate readings of legislations, both procedural and substantive, through the lens of contemporary socio-political and cultural settings, isn't it? Legislations will be subjected to readings. Legislations will be subjected to alternate readings, depending upon the both substantive laws as well as procedural laws on certain contexts. So when you employ the lens of the socio-political and cultural settings through the vehicle of judicial review, whether the constitutionalization has made things better, that is also something that has to be inquired, isn't it? Obviously, we find, see, several of the, we need to discuss, or we need to acknowledge at least the decriminalization, decolonization of laws and so many other things. And also the rights that are associated in such contexts, and redeeming an individual from the clutches of an age-old legislation which does not subscribe to the contemporary times. See, all these things happen through the vehicle of judicial review when you have a progressive progressive lens being fit according to analyze things, analyze the settings in the changing times. And why should this be employed? Basically, this could be to validate or integrate the outcome of the legislations, isn't it? You have heard about anachronism. I don't know whether you have been whether you are comfortable with that particular term. Stale, isn't it? Age-old legislations, colonial legislations, and that there is something called reason is the soul of law. When the reason ceases, the law should also cease. So there are so many stale legislations still continuing in the corpus of legislations, and which have a malignant effect on the system. And that can add on vulnerabilities on the people. Unless and until that is being removed, this will create issues, or this will create problems, and the whole surge forward will get backpedaled, isn't it? So when we think about, or when we analyze the legislations, when we analyze the fallouts of the legislations, whether it is procedural or substantive, from the contemporary constitutional discourses, that legislation may not stand that particular test, constitutional test. It is said that a law which has been constitutional and legitimate at the point of time of its enactment should be open for scorching judicial scrutiny when lapse of time occurs. When time lapses, that is why reason is the soul of law. When the reason ceases, the law should also cease. So that sort of legislations we call as anachronistic legislations, where we have come across in recent instances about decriminalizing so many provisions in substantive criminal law, etc., etc., isn't it? And the latest effect was the latest initiative on the part of the central government is to reformulate the entire perspective of the basic criminal substantive criminal law as well as procedural criminal law, evidence act, and so many other aspects, which in fact it is felt as outmoded, which again is to be discussed and debated in a profound manner. So again, you find when you discuss Mittu versus state of Punjab, you have discussed way back when you have learned law. 300 and am I audible? Correct. So am I audible?
Yes, sir. Perfect. Yes, perfect. Perfect.
Yes, sir. Yes, sir. Yes.
Am I audible?
Yes, sir. Yes, sir. Yes, sir. We can
Yes.
hear you, sir.
Okay.
Yes, sir.
So see, in Mittu versus state of Punjab, 1985 decision, isn't it? Says that, see, section 303 of Indian Penal Code was struck down as violative of Article 14. Why? Because, see, that is anachronistic. I won't go deep than further deep than this, because a convict who is undergoing a sentence for on the charge of 302. Suppose during the sentence days itself, he commits another murder, he shall be done to death. It's a legislative sentencing. So Article 14 was included. Article 14 was what? Applied. And said that, see, that is discriminatory, because sentencing is the realm of the judiciary. Sentencing cannot be done by the legislature, because it has to be applied, evidence has to be applied. It's a fact-finding process. So how can the legislative sentencing be part of a civilized jurisprudence? It cannot be there. So likewise, following that, recently we have found several of the provisions of the Indian Penal Code being decriminalized, isn't it? So that is a ground. So that is also constitutionalization. That is also to view things from the viewpoint of constitution and constitutionally ordained rights discourses. Then you have to open, unsettle, unbundle so many things, isn't it? See, all these have got telling effects on the forward journey of the society. So, social transformation is a long-term change process occurred in social norms, levels, relationship of social structure. But then there is a perception that has to be kept on the basis of a constitution and constitutional discourses, rights discourses, etc. That will give a strength to such sort of thinking process. That's what I was trying to tell you. Then I told you about the transformative component, right? This transformative component, I think beautifully christened by the Supreme Court as transformative constitutionalism, isn't it? So it is a conceptual bed for progressive constitutionalization. Constitutional angle, lens have to be employed, and then it gives a different kaleidoscopic view, right? Because constitutional values, then constitutional morality, and so many other things, isn't it? So the conceptual aspect is that transformative constitutionalism, the constitution wherein the basic idea of social transformation is inbuilt in constitution. Only thing that we have to discover is the modality that we have to adopt, that we have to embrace, that we have to shape up for a balanced sort of thinking process, right? So a differential reading of constitution has happened in the backdrop of transformative constitutionalism. So there could be formal reading, isn't it? Formal reading of an evolutionary document. Constitution is an evolutionary document. It started in colonial times, and you know how constitution was being made. The idea of constitution making. So many legal documents have made indelible imprints in that constituent, the idea of constitution making. So the process started way before or during the colonial times itself. So you have to read in so many things. History. You have to have a renewed outlook. Then precedents. It might supplant so many other things, right? Reading of what sort? Could be formal reading. Could be an alternate reading. Why alternate reading? Because it's a radical charter written on the moment of a, what? Can I say use the word historical rupture? That is remaking of a colonial state into a republican nation and transformation of its people from subjects to citizens. Again, I will take you, I'm reminded of the lecture of Mohan Gopal sir. That is indeed a beautiful lecture, taking you to the basic idea of that constitution making, and also the idea that the preamble reflects, and so many other areas and provisions of the constitution, isn't it? So, for a transformative constitution, that is a constitution leading the social transformation indices. That is what I was telling. What sort of approach you have to use? Can you use a conservativist approach or a formalist approach? Basically, conservative or formalist reading will not take you through that particular journey, isn't it? So there should be certain substantive reasoning. That is, you have to go behind certain things, the underlying principles, and also when the days lapsed, or rather what's punctuated by the happenings. What are the punctuations? Today, the particular law, the legal position is this. Then how it developed, how it evolved. What were the punctuations? Isn't it? All these things we have to take note of that. In Puttazomi judgment, isn't it? You find a string of decisions have been revisited. And those decisions which loses compatibility with the exposition, constitutional exposition of the present times got what? Sidelined, got buried. Isn't it? And some other judicial decisions which has got that compatibility, even though of extra years, still forward-looking judgments were given reinforcements. So, what you need is that a substantive reasoning has to be there. And how the courts looked upon that particular expositions, or rather principles, isn't it? When if you are a formalist, nothing will yield to you, because the lens that you use, in fact, is not having that much power to have a forensic reading. I told you that text has to be read in the context. You are a formalist, status quoist. You go by what the president has said, or not going behind what's being inscribed as in the letters. Then you are avoiding the responsibility, right? So such an interpreter, such an agency, such a system, dispensation cannot take constitution forward, or rather reflect the ever dynamic basic ideas in constitution adequately to the changing society. So if you just take into why this transformative constitutionalism has become so important in India, is because you can draw a parallel with the idea of transformative constitutionalism that was discussed in the context of South Africa. Says that in the transformative constitutionalism has been what imbibed, or rather has been put in words, actual words, say that a historic bridge between the past of a deeply divided society characterized by strife, conflict, untold suffering, and injustice, and a future founded on the recognition of human rights, democracy, and peaceful coexistence, and development opportunities for all South Africans, irrespective of color, race, caste, belief, or sex. See, it's a historical bridge that is being constructed. If we come back to India on that particular terms, see, Indian position is nowhere different. Deeply divided society, colonial rule, partition, famine, asymmetrical development, existence, etc., etc. So you need a continuously evolving document. That's why, again, I will shift back to Mohan Gopal sir when he said that our entire understanding of the constitutional law and the dynamics and discourse of constitutional as well as the constitutional law should be on the terms that it has to be discussed in the present continuous manner, continuity. So when you analyze the importance of a law reform as a catalyst for social change, the significance of rights, how rights have to be read, what should be the content, isn't it? The harsh iniquities that was in colonial India with that infamous divisions of class, gender, religion, etc., etc. How it has to be toned down. The Constitution emphasizes the importance of universal human rights, principles of equality and non-discrimination, isn't it? So that is why when we discuss the idea of progressive constitutionalization as a catalyst for social transformation, everything happens within that constitutionalization. So here it envisages, I told you that transformative constitutionalism is not something foreign, but that is implicit in it. That is where we have to find our conceptual justification. Why we have to ordain such a sort of thinking. So it envisages a mechanism in social change from an unjust past to a democratic future, using constitution as a tool to achieve this objective. That is the basic aspect. So you heal the past, wounds of the past, and guide us for a better future. You look forward to the constitution. You look forward to the persons who can interpret constitution. But when I say repeatedly, see, I would be interested in saying that it is not the solemn job of judiciary alone. It is a coordinated job. It's a job to be done between legislature, executive, and judiciary. Because everyone has to give its due, isn't it? If you have heard about the legendary jurist Ubendra Bakshi, when he classifies, he studied. In fact, he has been involved in part of so many in-depth or profound studies while classifying South Africa and Brazil in this particular category, transformative constitution. According to him, it becomes especially potent when adopted by the voices of human and social suffering and communities of resistance. You have to redeem it. And that is why it is so aspirational. You are looking forward to the future. You are not interested to lament or rather confined to those dark thoughts, dark era where you have been put down. You have to march forward, isn't it? So the whole idea of social transformation is being imbibed into the Constitution, and the lens is the transformative capacity of the Constitution, which holds that promise and an aspiration to transform. So everything starts from there, isn't it? So transformation is a permanent ideal. If only you employ that particular thought, it will create a space for you. Space for what? Space for dialogue. Space for contesting. New ways, new pathways have to be broken. Isn't it? Constantly explored, created. You have to tread back if that pathway is not correct. So you may have to retreat, but then you have to march forward with renewed vigor. But the idea of change is constant, isn't it? That's the difference between a transitional constitution and a transformative constitution. Transitional constitution is intended to serve during a transitional period until a permanent constitution is put in place. So various provisions in Indian constitution, in fact, is rich in being reflective of the transformative goal, like the preamble containing the aspirations, the goals of liberty, equality, fraternity, justice, isn't it? Not in its letter, but in its spirit and the cherished ideals added to secular, democratic, socialist, isn't it? Part 3 of the Constitution, Part 4 of the Constitution. So, new social order, the quest for establishment of a new social order through political power is implicit in Constitution. That is why aspirational Constitution, isn't it? This is an aspirational Constitution. That is, it is to open up and guide, not to constrain, but open up and guide political debate and also legislative decision making. Because, see, we are in a democracy where the legislative as well as the executive branches have to do a lot. So, they constitute law, they make law, they implement law. And it cannot be, the transformation cannot be, for the transformative component, you cannot exclusively look forward to the constitutional courts to deliver alone. No, it's a coordinated effort, isn't it? So, naturally, it's not a legal realist contribution. It has to be a coordinated effort. That is where I told you that even when the Part 4 and the socio-economic rights have been constitutionalized and has been declared, but still it is unsupported by legislative input as well as corresponding executive contribution. Globally, it is like that. So that is where it is left high and dry. That cannot be there, isn't it? So judicial legislation, it can be realized not only, it cannot be confined as a exclusive judicial contribution, isn't it? It has to be taken care of by the legislature as well as the executive also. So aspirational constitutionalism. It is a constitution building process, isn't it? Where the makers, the decision makers that have been installed on constitutional basis have to keep their goals very legible. The aspirations of the average individual very clear. And also the pathway that they have to take should also be very clear with them. So they have to be forward looking. That is where the constitutional borrowings that we have made over a period of time. See, our document that we address as Constitution, in fact, is a product of comparative, isn't it? Comparative, we have compared various aspects that have withstood the test of time in various jurisdictions, and we have adopted it. And we have adopted, as well as we have adapted to certain things also. So the influence between the constitution, we call as cross-constitutional influence, isn't it? From US we took this, from UK we took this, then Ireland, Germany, Australia, likewise. And after the constitution came into effect, again there was a heavy traffic into the constitutional domain by virtue of the international responsibility that India holds as a treaty maker. Many of our significant discourses in legislations as well as constitutional aspects have been regularly being contributed, have been significantly influenced by our the international conventions, etc. Gender justice, Then so many areas in environmental, in individual autonomy, in so many healthcare, in so many areas, isn't it? So after attaining independence, every polity has struggled to come into terms with the changing changing terrain. And there's a beautiful saying by Justice Harlan of the Supreme Court of the United States, saying that fundamental rights were framed in the backdrop of fundamental wrongs. And in order to understand the scope of fundamental rights, therefore, you must first ask yourself, what were the fundamental wrongs that a constitution intended to redress and transform? Isn't it? So, for that, constitution I'll just swiftly come across the idea of constitutional morality, because this has been used as an effective tool by the judiciary in keeping the constitution fit and proper to address the changing demands, ever-changing demands. What is constitutional morality? That is the morality set in constitution. Isn't it? And Justice Chandrachud has been very vocal about saying that for filling the constitutional silences to enhance and complete the spirit of the constitution, it has to be relentlessly employed. Isn't it? So, the twist with public morality, we have ended. Whereas you have to employ constitutional morality because it is transformation oriented. So, you have to demolish certain entrance to thinking, entrance thought process, the way in which rights have been interpreted. That is evident in so many decisions. Isn't it? One example I will cite, Article 14, right? You know. Traditionally, it is a classification test, isn't it? Reasonable classification. Twin test, intelligible differentia and rational excess. Then came the principle of non-discrimination or non-arbitrariness, etc., etc. But then, can you afford with that, or can you remain satisfied with that? No. New days, new challenges will be there. And that is why, again, the context in which the implication of a particular matter is being considered in the constitutional backdrop. The present Chief Justice, while he was a judge, said that there is something called a substantive disadvantage test in understanding Article 14. So that will take us to another area, right? That is where formal equality should not be is not the ultimate aim, but is the substantive equality. That is where we say that there should be anti-discriminatory law. There is in that lies the idea of what? Horizontality, horizontal application of fundamental rights and so many other things, isn't it? Horizontal administration of, or horizontal idea of fundamental rights is there in 15.2 section Article 17, 23, 24. But again, you have to find the progressive ways or the ways in which horizontality has to be established, because it's not a formal equality, that is the substantive equality, isn't it? So again, disadvantaged group of individuals, they are being treated in that particular manner throughout. So how to break that? You need to, again, you have to switch back to Constitution, come back to Constitution, what the Constitution has kept in store for you, isn't it? So in this way, the constitutionalization, in fact, it goes on. I'll just wind up by taking you to some stray incidents where the judicial interventions have on transformation lines were there. You know about Article 15.1, isn't it? 5 heads of discrimination is there. But there, a term only is used in the text of the Constitution. So that means only 5 exclusive tests for discrimination, a context in which discrimination can be alleged. That only has been employed, or rather has been interpreted in a much more emphatic manner, wider manner, to cover more heads of discrimination, like disability. Disability is not a head of discrimination there, isn't it? So again, you find why? Because a set of individuals who are vulnerable, who continues to be vulnerable, who cannot knock at the doors of the governance or the governance structure, continuously being relegated to a secondary citizen or secondary status. Despite judicial intervention, the systemic opaqueness is there. How to break open that? So 15.1, only, that particular only has to be understood in a different manner, isn't it? Another instance is merit. What is the idea of merit? Merit, particularly in the NEET case in 2022. Merit has been the term, merit has been deconstructed, saying that it is to be socially contextualized. It has to be reconceptualized as an instrument that advances social goods like equality as a societal value, isn't it? So meritocracy, merit, that has to be reconceptualized, contextualized. Again, Constitution has been applied there. Efficiency. You know about BK Pavitra case. I think it's in 2019. Holding it as BK Pavitra 1 and 2 are there. It held that stereotypical, what is efficiency? It is being understood in a stereotypical manner because it masks deep-rooted social prejudice against the marginalized, particularly in the matter relating to reservation and promotion, isn't it? Reservation and promotions. Then decriminalization of whole laws, homosexuality, adultery, marital rape, etc., etc. Then legislative anachronism, I told you about stale laws. Then you have heard about, I don't know whether you have come across the word romantic paternalism. A woman cannot be engaged in a bar. A woman cannot be allowed to walk down the streets during night time, etc., etc. Say that it's a romantic paternalism. In the guise of protecting, you are actually denuding the opportunities for them to come forward. So what is the remedy? The court found that, see, Constitution has got inbuilt remedy. Only thing is that you have to need to identify and discover it. That is constitutional feminism. So it's not the romantic paternalism that you need, but it's the constitutional feminism instead of that. That has to be put ahead of that. So again, constitutionalization. You have heard about Babita Punia's case, Lieutenant Colonel Nitisha's case, where women officers, short service commissioned officers were not allowed permanent commission. Babita Punia in 2020, I think, the substantial disadvantage test was used and the law was declared, but then nothing happened because the system is deep rooted in that. So in the next follow-up case, Lieutenant Colonel Nitisha's case, the court in fact dived deep into the systemic sort of opacity, saying that it is not a formal equality, it is a substantive equality. So the paternalistic attitude has to be removed, and that follow-up was yielded, or rather, that yielded many results, demonstrable results. Service SSC or permanent service commission was offered to many. Even many of the otherwise closed doors for entry to these services was opened. Anuj Garg, another case, stereotyping, isn't it? Then all forms of exclusions based in structures of hierarchy, caste-based, untouchability, and so many other things. Large untouchability, what is our understanding of untouchability under Article 17 over a period of time? That has been totally changed. Purity concept, pollution concept, everything. Where an opportunity is being denied on extra constitutional terms, then Constitution comes to the rescue. Right. So emancipation of the gender from remaining as chattels. You are being owned by somebody. You have no autonomy, no thinking. No, you cannot be on your feet, but you are being owned as a chattel. Isn't it? Adultery, marital rape, and so many other cases. Harshmandar case in Delhi High Court, where anti-beggary law was struck down, isn't it? And one thing, I think you just can't forget about the turmoil that happened during COVID times, isn't it? See, Constitution was in full flow. Constitutional interpretation was in full flow. Though it started late during that particular initial phase, then you find even the general respect that the courts paid to the executive in the matter of framing policy was also substituted by very active interventions in admissions in hospitals, regarding pricing structure, to even the management of dead bodies, isn't it? Where it was a health emergency. During emergency, executive becomes doubly strong. You call it as unbounded executive. But again, the court, in fact, even it said that, see, one very interesting word that has been used was as you know, there are several models of judicial review that is being employed according to the context. Some will be scorching one, some other will be having an intermediate effect. In COVID times, the virtues of the constitutional endeavor happened in the scope of a dialogic review. I think you have heard about that. Where Justice Chandragud said that if we do not engage in a dialogue with the executive to tide over the situations, because everybody will remain in panic, then the result will be diabolic. Where even you find the court gave idea to the executive that you have to do this thing, that thing, even though the central government resisted in very harsh terms, obviously, which is being criticized also. There are criticisms also, but still, isn't it? And see, likewise, you find the as a catalyst, constitutionalization comes as a catalyst. Obviously, it is a dialogue, isn't it? Obviously, it is a dialogue. So naturally, there will be certain, it will be like a pendulum. That balancing act has to be done. And if the court goes on a rampage, or rather as a usurper, then naturally that has to be resisted. But along with the courts, social transformation has to, if it is to come to reality, the legislature has to be very, very clear, isn't it? So the parliamentary time has to be optimally utilized, and the legislative procedures have to be followed very clearly. No decimation of Rajya Sabha or nothing like that. So naturally, see, one basic aspect is that legislative process does not come within the ambit of judicial review. So the legislature has to be very clear on that. Along with the legislature, the executive also has to take its cue. And that is where it becomes a coordinated effort. But then the idea of engaging constitution in the emerging areas will give it a much more resourceful handling of the matters, and a sort of not permanent durability and some other aspects. Basically, see, the engaging of the constitution makes it very, very sound. The engagement will be sound. Theory, the rights could be expounded, explained, could be enforced, could be reinforced. So in that way, constitutionalization will always be helpful in the matter of being serve as a catalyst in that particular process. But because transformation has to be essentially social transformation has to be essentially measurable. One thing, it should be demonstrable, because if it needs to be corrected, treading on wrong lines, then that has to be corrected. So intervention should be there at proper time and at proper place. I think I will wind up here. Thank you.
Thank you, sir. Thank you so much. Sir, we have a couple of comments and queries in the chat box.
Yes, please. Can you read it?
May I request Sanjay Jha to ask the question, or do you want me to read Sanjay Jha? Sanjay Jha, sir, could you just...
Yeah, I can read. As a law system is based on the reformative justice system, my question is related to the juveniles. They are treated as child, not offenders. But if the juvenile is a recidivist or a habitual offender, then these offenders should be treated with punitive approach with rigorous penalty, as the chances of the reformation is very less as per the present scenario. What is your perspective regarding the same within not defeating the constitutional framework as it always overlaps? See, this is a burning aspect that is being heavily discussed. Particularly, I think yesterday or day before yesterday also I came across some articles or some incidents wherein the matter that has been pointed by Sanjay has been there. Obviously, the law has to, because see, enacting of a particular law is not the final answer to an issue, because the factual dynamics keep on changing, and then naturally, see, there is a hue and cry regarding raising of consensual or age limit for consensual sex, particularly in the matter of POXO, where the high courts across the country keep on saying that, see, they cannot conscientiously deliver justice because a consensual note is always there. So an age has to be increased, but then that cannot be proceeded on unilateral terms because the courts cannot raise. So naturally, it becomes a legislative matter where the entire society has to take part in that particular conversation, and then has to come to certain reasonable, rational decisions. So these things generally happen, wherein this is not a final, or rather this is not the end or the solution of that particular evil, isn't it? So naturally, when instances galore, the system has to make certain rethinking on that. But then the balancing act has to be done. These are all polycentric issues. You call us polycentric because it has got different layers of thinking process to be ignited. There cannot be a one-size-fits-all approach. So that is where legislature is better situated in employing a dialogue, in initiating a dialogue, and coming to a logical conclusion. That's what I have to tell you. Apurva, as the term constitutional morality is not defined in the Constitution, is very crucial. The tool must not be used. That will lead to, yes, that's the elusive nature. Even I think, Apurva, you will be reminded of our former Attorney General, K.K. Venugopal. In fact, being very eloquent, saying that it has to die in the inception stage itself. It has to die where it took birth, constitutional morality, because it trenches into certain areas, which in fact, which is again questionable. Exactly. But again, see, then that this is a continuous dialogue where argumentations, contestations, etc., matters, and finally, the context, the employing of a concept based on the context has to be decided. So otherwise, it will be a judicial overreach. Even Article 142, isn't it? Article 142 is being held as an engine of overreach, or it's an arm of overreach is there. That is what is being generally considered. And Article 142, that's the provision to do complete justice to the parties. So obviously that is there. It's judiciary is not the panacea for all ills. But then again, see, but if any dialogue would be initiated, and this is to be discussed, because the elusivity of this particular term is at the time it's curse, is a curse, but it is an opportunity also. So that is where the balancing act has to come. That's what I feel. Then Apurva again is what's that? Is the moral duty of the courts to bring public morality in sync with constitutional morality. As often in the society is not matured enough, it must be taught to reach the aspirational notion of constitutional morality, as we say in the triple dialogue judgment. And yes, it's, but again, court has to sound. Court can sound that the public morality, it is equally elusive, and the basic term morality, if you just detach the word public or constitutional, it is fluid in nature. So naturally, there is an elusive nature to the concept of morality. and the society obviously is not matured enough. At no point of time you can find that it will be matured. But again, warning bells could be signaled, discussions could be there, or indication should be there that see these sort of moral decisions or convictions need to be revisited, and it should be revisited in the emerging context. And we need not constitutional morality need not be seen as an anathema. But again, if you go back to the constitutional, whenever our fundamentals are very weak, we have, or whenever we find our going difficult, we have to go back to our fundamentals, isn't it? So that is very, very important. So constitutional morality obviously cannot be overplayed or overemployed, but the courts have to sound warning bells or have to sound caution to society that the public morality needs to be differentially applied in different situations. And so I think that is part of the game. This dialogue has to be continually there, and this dialogue will be there. As a new law, as per my understanding, is highly inspired from the theories propounded in the subject of criminology and victimology. Do you think that it is a great step by government of progressive social transformation, just a vote bank to political? Which one? New law relating to women empowerment or something like that? New law, as per my understanding, is highly inspired from the theories propounded in subject. Criminology and victimology. POCSO Act or I don't know. I can't just make out. You said new law. New laws, as per generally new laws. I think this great step by the government of progressive social transformation is just a drama for the vote bank to protect their political seats. I don't know whether it is a question that is as part of, it's a continuing question or not. I think, Sanjay, you have to make it clear. Okay.
So there is one more question. That's
Yeah, you can read it. Thank you, sir.
towards the end.
Having both internal disturbance and armed rebellion and the external war under the same article makes for both same provision or to be followed. Is it unfair to treat external war and internal issues equally with the same procedure because their nature also differs? Having both internal disturbance and armed rebellion and the external war under the, I think it's emergency, right? You meant constitutional provision regarding emergency, I think. Under the same article makes for both same provisions are to be followed. Isn't it unfair to treat external war and internal issues equally with same procedures? Obviously, internal war and external aggression that is there for emergency provision. Okay. See, both are having different flavors and different complexion, different impact, differential impact also. So naturally, I think one cannot be a substitute and one cannot be clubbed along with the other, because the magnitude and the impact of internal disturbance and armed rebellions are different, which I think will be questioned at a later point of time, because both are criminal activities, but the magnitude and the impact are different. Could be questioned. The legitimacy of it could be questioned.
Is there any more other questions?
Ma'am, can I ask a question?
Yes.
Ma'am, can I ask a question?
Yes, sir.
Please.
So good evening, sir. So it was a wonderful session. I really like that statement. Fundamental rights are to be learned from fundamental wrongs. So my question is this. While explaining Article 14, you have mentioned about one particular test which has been formulated by Honorable Chief Justice D.Y. Chandrachud, which was a recent test. Apart from the two other tests, that is this intelligible differential test as well as this arbitrariness test. So could you please give some more insights about that particular test? It was a new concept to all of us, I think.
It's called substantial disadvantage test that came in the there is always a continuity, particularly in the matter of interpreting disability rights. You find a string of decisions have come which has given shape for which by which the court has given shape to one particular theory called reasonable accommodation theory, isn't it? Likewise here also, if you find gender stereotyping is a curse as far as the Indian society is concerned. And despite having these much provisions in the constitution, the constitutional there were several decisions, but those decisions hardly had combated this particular evil. So in that particular context, what happened in this Babida Punia case and Lieutenant Colonel Nitisha's case and so many cases afterwards, that was a raging discrimination that was there in the forces, where similarly circumstanced people, by virtue of the gender alone, were not allowed to apply for the permanent commission, because they have to leave the service after completing the short service. So in that particular matter, the court in fact went deep into it, because then again Babida Punia's case was not the first one. That was it was gender stereotyping was a continuous affair. Anuj Garg and so many other cases. So that was a continuous affair, and that continuity in fact resonated in the shape of substantial disadvantage test, because it's not simply a discriminatory affair. That was something that has been perpetuated for years, and despite several warning bells, the system was not ready to combat. System was not ready to yield to that. So that is where the expounding the niceties and fineries of Article 14 and anti-discrimination, or rather anti-discriminatory nature was further delineated, and found that this particular community, because of this gender, that women as a class have been consistently subjected to disadvantage, which in fact is a very important matter to be considered. And this is not to be confined to the earlier two tests, but here it's a gross discriminatory practice. And this has to be, if this has to be ended, or if this has to be put an end to, then the resource level of Article 14 has to be, as an anti-discriminatory provision, has to be substantially explored. That is where substantial disadvantage test has been put in place by the Honorable Supreme Court. So this is added to the continuous exercise of pooling in anti-discriminatory practices and embracing it, or rather enveloping it with a conceptual idea, that is substantial disadvantage. It's again an idea that has been put forward as part of anti-discrimination, or rather gauging anti-discrimination, measuring anti-discrimination.
Perfect, sir. Thank you.
Anantu Raj, do you want to ask any question? Anantu? Sir, there are one or two questions in the chat box. Sanjay has clarified that
supremacy of parliament and judiciary, there is a lack of. My question, in view of the proposed criminal laws, that laws are inspired from the theories of criminology and penal. See, I think that is still under discussion. So let the discussion take place, and then let it come to a final shape, and then we will take a call on that. I think that would be fair. The other question, Sanjay, you have said, is always a heated debate on the supremacy of parliament and judiciary. There is lack of check and balance theory which fails here in India. Could you please elaborate comparatively with the British law system and Parliament, House of Commons have more supremacy? They see the political idea has already changed, isn't it? Even in Britain, the things have changed in a big manner, particularly as part of a supra sovereign authority, supranational authority called European Union. They made Brexit, they made exit. And particularly when you consider the interrelationship, or rather the combating area between the legislature and the judiciary, after 1998, after the promulgation of the Human Rights Act 1998, it's a totally different terrain as far as Britain is concerned, because there the reflections of constitutional ideas and principles have been imported into the terrain of United Kingdom through the this particular act, Human Rights Act, where public authority, public power, and so many other things have come to the fore. So naturally, it's a watershed era prior to 1998 and after 1998. Now, whether the practices and the acts by the executive or some other agencies are compliant with 1998 Act or not, that is the question for the intervention of the judiciary. So even though there is no written constitution, effectively constitutional ideas have been imported by 1998 Human Rights Act, which in fact has changed the entire terrain of combat. If you can, I don't know whether it could be combat, but sparring between judiciary and parliament. Hereditary debate of supremacy. In India, I think it's very clear, right? About we have got judicial review as a basic feature, and it's only and the reason I will advise you, I will take a I will suggest you to eagerly follow the constitutional bench hearings, where the exchanges can be better had. You can have a clear idea of the exchanges between the government and the judiciary, and the comments that are in fact offered by the judges while they sit in the bench, and the way in which the submissions are being taken. I regularly follow the dynamics between the government and the executive and the legislature, particularly in most of the constitutional bench cases. It's a treat to watch, and we can draw conclusions from that itself.
So this just one more, sir. That is, it's from Shashidharan Unikan.
Thank you very much. No matter if we conduct the BRS conducted the states have also on their way to conducting. The outcomes of the census are going to affect their very fabric or consultation, which will is capable of adding social transformation. No, I may not be able to particularly comment on that, but still, see the while negotiating the dynamics of reservation in promotions, particularly series of cases have come, wherein in Karnataka, particularly a legislation was enacted, and that was challenged before the Supreme Court, and the Supreme Court said that it struck down the legislation, saying that you do not have an adequate quantifiable data for enactment of the legislation. And these days you can find, particularly on these matters, the court insists on quantifiable data as a justification for legislations, even as a justification for legislation. So in that respect, I think this is one particular aspect which may have a telling effect on the appropriate navigation of the policies regarding reservation, because caste census is important, because now I think this is a trend that has been set. Even for legislation, when it is challenged, the quantifiable data, if it could be quantified, because the Karnataka government readily agreed to Supreme Court government and constituted a Ratnaprabha committee, and that committee, in fact, had produced certain results or statistics. Again, based on which the legislature enacted a law. I think that was not interfered with the Supreme Court. So quantifiable figures become very important, particularly in these matters, because reservation itself is grounded on as a transitional provision, not a permanent provision. The past of the Constitution has come in, but still, even children exist despite various reasons. It's because of the lack of the implementation of true spirit of is how this discrimination of women can be changed, can be made more or less equal to their male counterparts. How can I answer this? A big question. Yeah. I do not have any specific medicine to offer, because a lot of diagnostics have been done, and the things have been identified. As you correctly said, the implementation part, I think the present idea of providing a reservation of seats to the women, I think that will be an excellent initiative to mainstream women, so that you can be part and parcel of the policies, you can be part and parcel of the implementation of policies and also laws, where when you will come to the driving seat, naturally that ability part will also be improved. I think many of the discriminations that have been identified by the courts of law, where consistently the courts have been very clear about the discriminations perpetrated. Yeah, I think you've heard about the rights of women doing household duties, household chores, isn't it? Even they
Yes,
been mainstreamed, even though as part of computing the insurance amount. Anyway, this has been a big revelation that even the worth of a so-called housewife, in fact, is being reckoned on very strong terms and is being mainstreamed. So I think discrimination has to end, and for that also you cannot. You have to come forward and question the discriminatory practices before the fora, and then you have to keep your foot down. Otherwise, see the government is doing things, the legislature is there, legislations are there, the implementation part of it, it's a struggle, or it is a you have to struggle hard, and then you have to come on top of that.
Thank you, sir.